Welcome, everyone. My name is Joe Salazar. I'm an attorney with the Lewis Brisbois firm in our Sacramento office in California. I'm here this afternoon to provide the general legal overview of this component of the video series. By way of background, I'm a partner, as I stated earlier. I'm within the environmental and mass tort practice with my firm. I've been doing this for about 25 years now, and defending public entities has been a large part of my practice. I've been defending everything from reclamation districts to irrigation districts, municipal water suppliers, and really the full gamut of water suppliers
over the years. As part of that background, I've taken roughly 25 plus cases to jury verdict over the years. So I've got a little bit of a feel for what juries are looking to in these inverse condemnation cases and public liability cases in general. So let's start with the general legal overview, and within the brief time we have allotted here, my goal is not to get you to a point where you're going to pass the bar, much more modest than that. I just want you to have an appreciation for the legal views that are out there and perhaps some exposure pathways that you're not familiar with. Now, I think given who our audience is, you're pretty familiar with the general government code, the Tort Claims Act, and the various liability pathways within that act. Most often we have the dangerous condition of public property and all the different variants that come from there. I'm sure you're also probably familiar with a lot of the immunities that come within the government code as well. There's three of them that are really most applicable to our video series here today as it applies to inverse condemnation, and those are the ones within the firefighting realm. So let's talk a little bit about the immunities that are available within the government code, specifically as to fire protection. And what we have are immunities that apply to whether or not you even provide fire protection service. There is no liability if you choose not to provide that type of service. There's immunity if there's a failure for providing sufficient personnel, sufficient equipment, or even sufficient facilities. And there's a third immunity that protects you for injury resulting from the condition of that fire protection, the facilities and the condition. So if you have old and antiquated equipment, even then you still have an immunity. And of course, the beauty of an immunity is it's an immunity. You're completely void of any type of liability. And that's been the case through most causes of action against fire protection activities at the public sector. Now, that's all well and good, but as we move away from your traditional tort-based, fault-based liability causes of action, you see that I have this slide is set up with two different silos of liability, if you will. On the left, you have your legislative liability under the tort theories as well as your immunities. And in your second silo to the right, that's your constitutional liabilities and exposure. And it's important to understand that within that silo, you don't get the governmental immunities. And that's a big concept to get our hands around, because the immunities that are so substantial aren't available when you have an inverse condemnation cause of action coming away or coming at you. And the brief explanation for that is that the constitutional right that you have for protection or for the inverse condemnation cause of action, it can't be abrogated by the legislature. That's your constitutional right. So with that in mind, let's talk a little bit about what is inverse condemnation and where it comes from. Well, it derives from what's called the takings clause within the Constitution. And that's both at the state level as well as the federal. And it essentially says that the government can't take your property without just compensation. I don't think that's really remarkable to a whole lot of people. And it's that just compensation clause that triggers the liability to pay. Now, most of us think about the takings clause in the eminent domain concept. And we see that, at least in California currently, for the high-speed rail situation. We see it for perhaps the twin tunnels that are going to be developed up in the San Joaquin Delta. The government will take that land and have to pay the landowners just compensation. Now, the interesting aspect of that is the government is initiating the legal proceedings under what's called eminent domain. There are many times, and this is the inverse situation, where the government has an oops moment, where they do something that takes somebody's property, but they don't mean to take it. They don't want to condemn the property. That's when the property owner whose property has been damaged initiates the legal proceedings, and that's the inverse condemnation action that we're talking about today. Now, the two different mechanisms, they're very similar. They're really the opposite sides of the same coin. At the nuances, there are some differences, but for today's proceedings, I think we can pretty much consider them almost co-equal. Now, from a procedural standpoint, if there is a taking or not, that is the liability determination, that is determined by a judge. And so the judge will see if there was a taking for public purposes. If so, then the issue of damages are determined by a jury. Now, there is, and this is kind of important, there is a mechanism for an early determination, and that's the civil code section that's on your screen here. I do want to let you know, though, that there was a case that came down in March that said that that procedure is only available in the eminent domain world and not the inverse. The circuits are, excuse me, the Court of Appeals are split on this. I imagine that it's going to go up on appeal for a later determination. So let's talk a little bit about the development of the inverse condemnation doctrine. Initially, it was your typical situation with your water companies. You have a pipe that bursts, you have a sewer line that backs up, goes into somebody's home, and those are pretty much settled law. Those are strict liability situations. You cause the problem, you have to pay for it. And the justification for that was that because the public as a whole gets the benefit of this public system, the public as a whole should also pay for any burdens that arise as to one particular landowner. It shouldn't just fall on that one home that gets backed up and flooded. And so it was really an equitable doctrine that developed. So the early applications of the inverse condemnation doctrine really were not controversial. Flash forward a little bit to California in the 1950s and 60s. The state's population is expanding, residential growth is growing, and for better or worse, we're developing within what are traditional floodplains. And so the government is now beginning to undertake flood protection activities. And so the law started to develop at this point in time, in particular a Professor Van Alstyne at UC Berkeley in the late 60s, as inverse starts to develop. And the problem that was occurring is governments didn't want to undertake flood protection because they were strictly liable if it failed. Big exposure. So the court started to fashion an additional doctrine within inverse condemnation. And so within the realm of flood control, the law became a plaintiff must prove the public improvement was a substantial cause of the injury and that the public project design was unreasonable or the conduct of the public entity was unreasonable. So we have this injection of this reasonableness requirement now that gives the public entities, if not a safe harbor, certainly something to talk about should there be an actual flood. And the rationale as to why the court went there is because there was a public policy, a very strong public policy, to allow the government to enter into flood protection activities without taking the big hit. And of course that has developed over time as California and the municipalities and even our irrigation, reclamation, and other water districts participate in flood control. The thing I particularly like about this slide is this is a picture of the 2004 levee break in the San Joaquin Delta College and that, Delta area. And the actual levee you see there, that was my client's levee that broke. Within 3 days, 12,000 acres were under 14 feet of water. And so the question is, can you really transfer that risk? And I think the practical reality that we all have to recognize is that there are some risks that are just uninsurable, and ultimately this was one of them. So the question becomes, now that we know that the law has morphed into this reasonableness component for flood, what will the law will be applied when it comes to the wildfire scenario? And unfortunately, we don't actually know at this point, but we can make certain predictions. And so the prediction is that we will see an expansion of this reasonableness component into the wildfire scenario. And so the elements that you'll have to prove if you're the plaintiff are that these 5 elements that are on the screen. The first 3 are pretty easy to prove. The plaintiff had an interest in the land. That's pretty easy. The defendant participated in the planning, approval, construction, or the operation of that public improvement. Probably not a big fight going on there. Item 3, the plaintiff's property suffered damages. No big controversy there, although certainly the extent of the damages will always be a question. But it's elements 4 and 5 that I think that's where we're going to see the big legal fights taking place. And that's element 4 is failure of the public improvement was a substantial factor in causing the damage, the causation factor, and that the failure was attributable to some unreasonable conduct. And of course, everybody can throw everything at the wall, as much mud as you want, to try to prove or disprove that component. So why do I think that that reasonableness component will come to play in this particular case with the wildfire scenario? And part of it was an analysis of the Yorba Linda matter, the complex fire, the freeway complex fire of 2008, which you'll hear a lot more of in the next component. That case involved a fire that hit the Yorba Linda Water District area, and I'll go into a couple of those facts, but through some early law in motion, we got some insight of what the court was saying. And what the court did say in that particular case was there is no reason why a flood case should not be applied to a fire case for inverse condemnation. Now, that was just at the law in motion stage, so it's not an appellate opinion. We can't exactly rely on it yet, but I think it makes sense given the rationale for flood fighting, for firefighting, and at least we've got a hint as to where the court may go at this point. Now, a couple facts from the complex freeway fire of 2008. First of all, Yorba Linda, the water district there, didn't start the fire. They were as much a victim as anything else by that. To give you an idea of the magnitude of that case, at one point it was traveling 14 acres per minute. Extremely fast fire, extremely hot, extremely large. It was fueled by high winds and abundance of fuel on the ground. And the homeowners who lost their homes claimed that liability arose because the fire suppression system, actually the water delivery system, failed to put out the fire. And keep in mind that Yorba Linda only was providing water and sewer services. It was not a fire protection district. And much of the litigation focused upon a fire flow booster pump that didn't fail. It operated just fine until it was inundated by the heat and the smoke of the fire itself, and it shut down as it was designed to do. Multiple homes were lost. Mark Antonio will be here later on, and he'll describe to you some of the real carnage that took place. The matter ultimately went to a binding arbitration, and liability was found against the water district for sums that will probably make your eyes roll. That being said, from the legal standpoint, there is no appellate case out there right now on that particular scenario. There is no quotable law that we can use at this point. Flash forward to the fall of 2017 with all the wildfires that occurred in California. We know there's litigation going on there. I think it's probably pretty reasonable to think that we're going to get some appellate decisions down the road for those particular cases. But the important part, at least at this point, is that the concept of inverse condemnation in the wildfire scenario clearly whetted the appetite of the plaintiff's bar, and that's exactly what we're seeing right now. So let's talk about some of the defenses that you have in these inverse condemnation cases. And I talked about one a little bit earlier, that causation factor. Did some failure of your public improvement cause the damages at place? And let me read to you what the causation jury instruction is. And it says, it's what's known as the substantial factor test. And it says, a substantial factor in causing harm is a factor that a reasonable person would consider to have contributed to the harm. It must be more than a remote or trivial factor. It does not have to be the only cause of the harm. So that's what the attorneys argue over, whether or not this particular failure of the public system was a substantial factor. And so let's look at that within the wildfire scenario. The argument is pretty simple. It's that the public improvement didn't start the fire. The public improvement was inundated by the fire, and as you might imagine, water delivery systems don't burn down structures. Fires burn down structures, and therefore there's no causation even when there's failure of the water system itself, because the water system wasn't spewing fire. A pretty good argument, I think, but as yet untested with the appellate courts. The second area where you have a potential defense is what's called the subsequent or independent intervening cause. And a typical situation where that would come to play, let me use the flood scenario as an example, and Katrina in particular. The flooding of New Orleans and the litigation that came out of that, the courts typically held that the cause of the flooding wasn't the flood control structures. The cause of the flooding was the ocean surge that overwhelmed those structures. And so you have a situation where Mother Nature just simply outpaces what the design is, and no matter what you did, within reason, the flood was going to occur anyway. And here you have a similar argument, at least within the Yorba Linda context, is that this fire was so great it simply overwhelmed the system and therefore was an intervening cause. And that, from a legal standpoint, breaks the chain of causation. So, but those are kind of the easy scenarios because you've got a large category hurricane and you've got a huge wildfire. What do you do if your weather event is a tropical storm, if it's a atmospheric river, as heavy storms are now known as? What happens if your fire is not quite a 12-alarm fire, but it's a 3-alarm fire? Where is that line where the intervening cause will come in and break causation? Presently, that's unknown. The third area where you have your defense is, were your actions reasonable under the circumstance? And actually, I just misstated that. It's the plaintiff that has to prove that your actions were unreasonable. And that's an important distinction because if they fail to carry their burden, you don't have liability. And we'll talk about some of the reasonable actions you can take in a moment here. So just to kind of take another review at what we've talked about so far, inverse, it's advantageous to the plaintiffs and it's attractive to the plaintiffs because they get their attorney's fees on top of everything else as well as expert fees and the like. It's attractive because statutory immunities do not apply. In terms of who tells you if you're liable or not, the judge does that. I, as a defense attorney, like that in most circumstances. The compensation's decided by the jury. I don't like that in most situations as well. I think currently the better case law for the plaintiff exists in the California state courts as opposed to the federal courts. Presently, I think getting jurisdiction from the federal courts would be difficult anyway. I say it's better in California right now because there are these open questions. And open questions make for, you can ask for whatever you want until the judge tells you, sorry, that remedy is not available for you. General damages typically are not available in inverse cases because they're property related, but they are available in the flood cases. So query whether or not that extension will occur in the wildfire scenario as well. And then when it comes to the unreasonableness burden, boy, the sky is the limit there because you can imagine sitting at a deposition and you just get peppered with questions. Did you do this? Did you do that? Why didn't you invest more here? Why didn't you invest more there? Economics tells us that we can only do so much. And the reality is, in today's, I think, political climate, is the government is expected to do many things for you, but the practical reality is budgets are what they are. So here are some of the things that we know from a precedent standpoint, things we can at least rely upon at this point. Your liability is strict if it's your typical pipe bursting, sewer backup situations. And in the flood control situation, you've got that reasonableness factor to consider. We do think it's going to extend to the fire situation as well, but we don't know at this point. One of the important things when you're managing your risk is to understand what scenario are you in so you can quickly analyze your risk, and especially the potential of having to pay opposing counsel's fees. What is the open question, and really the reason why we're here today, is what is going to be the standard in the firefighting scenario when your water system fails for whatever reason. You'll hear about what happened to Yorba Linda, and it's not a pretty scenario. As I intimated earlier, we've got fires, massive fires in the fall of 2017, so I think that we're going to probably get some appellate relief or some indication at some point in time in the future. So what are our takeaways from today's presentation? We know that the likely legal standard in the wildfire situation is going to include that reasonableness concept. We also know that the prevailing plaintiff in inverse gets their attorney's fees, so you need to make an early determination whether your strict liability or the reasonableness standard, because that may determine whether you want to settle your cases out earlier rather than later. What are still our open questions? Causation. Was it the fire that caused the problem or the infrastructure's failure? Or was it both? As you heard earlier, the substantial factor test, there can be more than one substantial factor. Open question, how big does the fire have to be before you break that chain of causation? Certainly if the fire is larger than the designed capacity, firefighting capacity of your system, you've got a pretty good argument, but you don't have appellate authority one way or the other at this point. And the final point I'd like to leave you with is what are the optics of the situation? And as a trial attorney, I'm always very concerned with optics because ultimately that's what sticks with a juror or with the judge. And so some of the optics I'd like you to think about in how you operate your system is how good are your maintenance records? How often are you out looking at your system, testing it, making sure it's up to date? What is the redundancy in your system? Yorba Linda had tremendous redundancy in their system and still got hit with liability. What is the compliance standard of your infrastructure with the current state fire code? Is it behind the times? Is it outdated, or have you even looked at that issue? What does your website say? Are you telling the public that you are going to protect their structures if you come to live within their district? Have you overstated what your capacity is, or have you put out some type of disclaimer along the way? Redundancy, I think we talked about that a little bit earlier. And then finally, the design criteria that you have. Are you over-designing? Do you have excess capacity? Are you just making the bare minimums? The reality is with engineers these days, if we ask them to design to a certain capacity, they can do it. But can your district afford to do so? And are you really wasting away public assets preparing for an event that has a 1 in 100 chance, and you're taking perhaps assets away from a better use? Tough decisions to make, but I'd rather you make them before something bad happens as opposed to being asked about it in a deposition and you never considered it. So these are some of the many things that I'd like you to think about in running your district as it applies to were you being reasonable at the time or not. I thank you for your time and your consideration, and best of luck to you.